To introduce our panelists, there's Professor Michael Trebilcock, who I have actually have a tenuous relationship with him. He doesn't know this, but as I was thinking over the week about how am I going to do this introduction, I looked up to the spine of a book on my wall, and I realized that's where I know the name from. Jason Nyers, my contracts prof, and Professor Trebilcock here coordinated and wrote my contracts book. So I won't say how I did in that class, but it was a long time ago and it probably doesn't matter any longer. And then Angie Redecopp works for an organization called International Justice Mission. I find it a very exciting organization. My wife previously worked for them as a fund developer, and they have very exciting work in developing countries enforcing things like property rights and liberty. And it's a very exciting story, an exciting organization. So without further ado, we'll have Professor Trebilcock come and do his presentation, and then Angie will respond, and then we'll open up to questions at the end.
Thank you very much, Derek. Let me introduce my comments by setting a bit of a context. I was driving down yesterday afternoon on my way to this forum from our retirement farm. For those who can't follow New Zealand accents, farm, F-A-R-M, farm, south of Collingwood. Now, retirement farm, I'm not actually retired. My wife is. She lives there all the time, and she's constantly pressing me to retire like her, and I'm resisting. She says, the reason you won't retire is you don't have any hobbies. This is also true. My work is my hobby. She says, well, why don't you take up new hobbies, wood carving or watercolor painting, or volunteer at the local community library. All of these are anathema to me. But anyhow, driving down, I noticed an avenue of opportunity I previously hadn't occurred to me. This was on a rural road north of East Caledon, farms, old Victorian farmhouses, and outside of one of these farmhouses was a great big sign, bagpipe lessons. Bagpipe lessons. Now that's something I haven't considered for post-retirement. As I thought about it further, I thought, well, I presume they have to practice between lessons, right? So this will alienate my wife, and disorient the two Labradoodle dogs that we have. So I dismissed this as an option. But in some sense, what I want to talk about today is bagpipe lessons, not in East Caledon, but in the Sub-Sahara, and whether they're likely to be a bigger sell there than I suspect they are in East Caledon. Now, over the post-war period, theories about economic development or broader conceptions of development in the developing world, what we used to call the Third World, have taken many different forms, from capital fundamentalism to structuralist reforms to dependency theories to neoliberal or Washington consensus theories, and so on. But in the last 20 years, a consensus, I think, in development circles has emerged that actually makes lawyers assigns lawyers a central role in the development equation. And that is the view that, to quote the mantra, institutions matter, or governance matters. And the reason why some countries are poor and others are rich, some countries have good institutions and others have bad institutions. Now, in one respect, this is an encouraging shift of perspective, partly out of self-interest. It makes lawyers more important, right? So why would one resist this shift of perspective on that account? But secondly, it seems to provide a basis for developing countries taking an optimistic view of their future. We're talking about their institutions. So if they're bad, they can fix them, right? They're not captives of their culture, history, geography, the international economic order, If they have bad institutions, they can fix them on their own, or if necessary, with outside assistance. In the last 2 decades, literally billions of dollars in both official aid and informal aid of the kind that Angie's organization is associated with, have been invested in institutional reforms, including legal reforms in developing countries. And now these reforms take many different forms. Some are directed to reforming the political institutions of these countries, promoting democracy and civil and political freedoms. Others are directed to promoting and strengthening the rule of law in developing countries where this has hitherto been deficient. Yet other reforms are directed at substantive areas of law, such as property rights, which is what I am going to focus on in my comments. But I think it's fair to say, as a general proposition, the initial flash of enthusiasm for this new perspective on development, this institutional perspective on development, has somewhat dulled over time in the face of the realities of achieving effective institutional reform in many developing countries. That is, the challenges have proven more formidable than many of us initially supposed. Well, I won't talk about democratic reform or rule of law reform today. It is worth noting that attempts to promote democracy in developing countries where it has previously either not existed or had a tenuous footing have not been dramatically successful. And just to cite a few examples: Iraq, Afghanistan, Libya, Egypt. George W. Bush, in one of his early State of the Union messages, said that his administration was committed, quote, to carrying democracy to the darkest corners of the world. This has not proven to be such an easy challenge. And I think the evidence on rule of law reform is again mixed to poor, despite the vast amount of resources that have been devoted, both domestically and internationally, to rule of law reforms. Now let me turn to property rights and development. A prominent perspective on this is associated with the writing of Hernando De Soto, a widely respected and lauded political economist from Peru. In a book, The Mystery of Capital, Why Capitalism Triumphs in the West and Fails Everywhere Else. That's the title of his book. He argues that the single most salient factor in explaining why some countries are rich and some are poor is rich countries have strong forms of property rights protection and poor countries don't. So if you're looking for a silver bullet, or poor countries are looking for a silver bullet that would put them on a much stronger development trajectory, property rights reform, if you accept De Soto's view of the world, would be at the top of the list. And in his book, he documents the weak state of property rights in many developing countries, in particular the lack of formalization, that property rights regimes in many of these countries are typically informal or customary. And he concludes that the total value of real estate held but not legally owned by the poor of the third world is at least $9.3 trillion, which he characterizes as, quote, dead capital. So there's the strong sort of pro-property rights view. And his views on this have been very influential in circles such as the World Bank, which over the last number of years have strongly promoted formalization programs, formal registration of title, particularly to real estate, to a lesser extent personal property, in many developing countries, titling systems where they hitherto did not exist. So in my comments, I want to ask are De Soto's views on this new silver bullet, right? And I have to tell you, the development, the history, intellectual history of development thinking is littered with silver bullets, right? If you only did this, right, you'd be rich, right? So I view this as one of the most recent in this long list of silver bullets. Is it really as simple as just formalizing and titling ownership to real estate? Would this make poor countries rich? Well, the argument for formalization and stronger protection of property rights runs along the following lines: that if people are guaranteed exclusive use of resources, so it's clear that A owns Blackacre and not B or C, then this will lead to resources being used more efficiently because A captures all the benefits from more efficient use of the resources. Secondly, that security of tenure and easy transferability of property rights increase access to credit. You can borrow money against the title to your assets and presumably invest this in many cases in productive uses. Thirdly, security of tenure increases incentives for investment. If I clearly own Blackacre and nobody else does, I have an incentive to improve it, make investments in enhancing its value. And finally, security of tenure decreases inefficient and wasteful competition for resources. That is, conflicts, socially wasteful conflicts amongst contending claimants to particular assets. Think of, take an extreme version, the conflicts over, often violent, over claims to mineral resources in the Democratic Republic of the Congo, right? A misnomer if one ever could think of one. So these strong arguments for promoting stronger property rights as a central element in a pro-development strategy. Now it turns out, however, that both here and in other contexts, like democratic reform or rule of law reform, reformers are almost never writing on a blank slate. That is to say, while property rights may be weak in our terms in country A, it's rarely the case that they're non-existent. That is to say, something exists out there, maybe very, very customary, informal understandings of who owns what, customary ways of respecting each other's property rights, customary ways of transferring entitlements. That is to say, the state of nature, maybe the DRC is an exception, but the state of nature is rarely the typical case. This poses major challenges for external reformers, right, who typically will not be acquainted with whatever the informal or customary understandings are down at the village level. It's going to vary even within countries, but certainly between countries. So the sort of formal-informal divide is important. So simply charging into a country and saying we're going to title your land from coast to coast or whatever, top to bottom, ignoring whatever understandings exist there already and assuming that something magical is going to happen as opposed to various other somewhat negative potential consequences. Again, the law of unintended consequences discussed in the previous panel. may indeed follow. So let me list some of these either predictable or unintended consequences. First of all, significant costs are entailed in setting up a land registration system, including initial surveys if a country has no formal title records at all, cost of updating the registry through time to reflect changes in ownership of or changes in the composition of the landowning group. This is not a trivial cost for a small, poor country. 2, formalization and individualization of land tenure may seriously undermine traditional communal understandings of tenure that historically have often provided an insurance role for members of land-owning groups, that they can always count on going back to the communal land if other economic activities fail, and may result over time in the emergence of a landless class with few other economic opportunities. 3, formal rules may undermine effective informal institutions by creating dysfunctional conflicts between the two regimes. Often traditional notions of property rights emphasize functional conceptions of property rights, where Group A may own a certain piece of land, but Groups B, C, and D have various usufructuary rights, rights to gather firewood, pick berries, fish, traverse, or whatever, whereas our understanding of property rights tends to be based on spatial notions, right? This is my land, right? It's not, and you don't have a right to fish or hunt. So if one creates a formal system based on spatial notions of property rights, but informal systems emphasize much more functional conceptions, these systems are going to interact often in highly dysfunctional ways. Formalization programs, depending on how they're designed, can expose latent divisions between or among claimant groups that have previously lain dormant, simply because of the finality involved in finally, right, formalizing who owns what. I saw this myself in Papua New Guinea in the early 1980s, where 97% of the land is communally owned and none of it titled. Previous efforts by the Australian colonial administration to title the land led to all kinds of conflicts between adjacent landowners who were quite happy to let sleeping dogs lie until the government officials arrived to survey and mark out boundaries and so on, in which case often local tribal wars would break out over boundary demarcations and the like. Flaws in the titling process are likely to be exploited by politically and economically powerful groups at the expense often of women or other marginal groups. This is again not hypothetical. A number of titling experiences reveal this. Even assuming the system's well designed, deeply entrenched informal norms may impede its successful implementation, as I've already implied. And finally, there are obviously important institutional interconnections that have to be addressed. And here De Soto seems to me to be naive, just going around the slums outside of Lima, Peru, which I've seen, and issuing pieces of paper to people is obviously an exercise in futility unless they're enforceable, right? But to render these entitlements, property rights, enforceable implicates a whole set of other institutions, the police, the courts, and the like. Otherwise, these property rights are not worth the paper they're written on. So the police system doesn't work well, the court system doesn't work well, and so on. Just surveying land and giving the current occupants pieces of paper is largely an exercise in futility. So I think the experience with property rights reform in developing countries in the last 20 years has been mixed to poor. I don't want to say it's always been a failure, but it certainly falls well short of this, I think, highly euphemistic view that De Soto takes. My own view is that, as the title of my book suggests, Dealing with Losers, the Political Economy of Policy Transitions, there's major advantages to moving incrementally rather than dreaming up grand top-to-bottom country-wide schemes. So I would, for example, favor sporadic registration of titles rather than systemic. That is, instead of trying to register all the land in the country, create an option for landowners who want to register their title, maybe in order to borrow money, give them an option in addition to what they have under their customary system. But if other landowners are happy with the status quo, leave them alone. And to the extent one is going to engage in more systematic registration systems, I favor, again, moving incrementally, respecting customary or communal property rights rather than moving too quickly to an individualized, fully alienable conception of property rights. So as not to create major forms of cultural dissonance with traditional understandings of property rights. So you register land in the name of groups rather than individuals. And one could imagine other reforms that tighten up the decision-making structure within these groups so that it's more decisive and less messy. But there are a range of incremental reforms that I think have the virtue of reversibility in the event that unintended consequences are revealed, and one avoids the all or nothing, I think, quality of some of the more ambitious proposals for property rights reform, where all or nothing may often end up being nothing. Thank you.
I spent most of my career practicing corporate law with Borden Ladner Gervais, and then the last few years working with International Justice Mission, where rule of law is why we get up in the morning. But I really haven't considered this many legal issues and rights and freedoms since law school, so it's been a lot of fun. I'm going to be talking about what IJM does in other countries to advocate for people's protection and their property rights, specifically in Africa. Meanwhile, though, many of you are right here at home advocating for my rights, and I thank you for that. Since leaving private practice about 3 years ago, I've been in an interesting space where, on the one hand, I spend time teaching at a small university in Calgary, and on the other hand, I work for an organization that advocates for basic human rights in developing countries. This is a wonderful mix, academia and activism, much like the mix that we have in this room. And if I've learned nothing else in my last couple of years working for an NGO in developing countries, both thought and action are needed in order to tackle some of these weighty problems that we're facing in the world. So I enjoyed both reading Professor Trebilcock's work and hearing him speak on the challenges in achieving property rights for folks in developing countries. IJM has had to face many of these challenges. And I'm going to share with you about some of our work, specifically our work in the area of what we call property grabbing in Uganda. So like you, a concept that I hold dear is the concept of the rule of law. In its most basic form, we interpret this as nobody should live above the law and everybody is entitled to access to the law. However, this rule of law does not hold true for about half of our world's population, the poor portion of our world. In many countries, as you know, there are laws on the books, but they're not being enforced. We teach our kids to call the police if they're in trouble. I have a 10 and 12-year-old. I teach them if you get lost, you find somebody in a uniform. In the countries that we work in, parents are generally teaching their children not to call the police because the police can't be trusted. Children are particularly affected by this through sexual abuse, sex trafficking, and forced labor, to name a few. Women also tend to be vulnerable to this: rape, forced labor, property grabbing, which I'll talk about, and other violent acts. Studies show that if you're a female between the ages of 15 and 44, so that would capture many of us in this room, we are far more likely to die or be harmed by gender-based violence than cancer, motor accidents, war, and malaria combined, especially if you're poor. It's estimated that there are about 30 million slaves in the world today. This is one of the largest criminal industries in the world, second to drugs and tied with arms trafficking. I'm going to send around an IJM overview sheet at the end, but in really basic terms, we go into developing countries and we work with local authorities on cases. We investigate brothels with young girls, brick kilns with families that are forced to work there, along with other types of violent crime. We then rescue victims, provide or find appropriate aftercare for survivors, and then work within the legal system to bring criminals to justice. As we do this, our ultimate goal is to strengthen the existing justice system through police training, working with community groups, and advocating with government and media. So let me demonstrate this by telling you about Grace. Grace, her husband, and their 5 children live in Mukono, Uganda, which is in Eastern Africa. Or in Edward's case, lived in Mukono. As is the case with many young men in Uganda, Edward died young. In his case, he died from sickness. As is often the case in many areas in Africa, Uganda specifically, individuals more powerful than Grace quickly moved in to take her property after her husband's death. In Grace's case, it was her brother-in-law. He kicked Grace and their children, Edward and Grace's children, off the land, and Grace had nothing. She and her children had become victims of what we call property grabbing. Without land, Grace could not farm to feed her children. On her own, Grace began many visits to the government office which oversees such things. She would, and this was over 25 miles away on foot. She would answer questions, fill out paperwork, but the government officials always had more questions, and typically more requests for money to help with their work, which Grace did not have. So Grace always needed to come back over and over. In 2008, Grace heard about IJM through a local group. IJM investigators started meeting with Grace's family, neighbors, and friends. Some attempted violence ensued with her brother-in-law, but this was fairly quickly stopped as Grace and those around her started to feel empowered to stand up for Grace's rights. Eventually, after many trips to the government offices and a number of meetings with Grace's brother-in-law, the brother-in-law agreed that Grace could have the land. So this solved half the problem. What Grace still needed in order to have long-term protection was title to the land that she was entitled to, or their version of title. This is not a simple process in Mukono County. I still have trouble saying that one. Stalled land surveys, lost titles, backlog bureaucracy. This typically takes and did take months of time and effort, 2 years in fact, and this was with IJM lawyers directly advocating for Grace. Now Grace does hold official title to her land, her children have a safe and secure place to grow up, and Grace has the means to feed her family. So let's break this down a bit and talk about some of the statistics and the legal implications behind property grabbing in Uganda. Then, using some studies and papers that IJM and others have completed, I'd like to talk about the concept of bringing sporadic, as Professor Trebilcock referred to, institutional reforms or societal reforms in this context. So for a woman or a family living in poverty, your house or your small patch of land provides your crucial source of shelter, food, and income. For many, this foundation isn't secure. Property grabbing is the common phrase used to describe the set of crimes through which vulnerable people are driven from or otherwise lose access to their property. This could be through physical force, forgery, threats, intimidation, sometimes property destruction. In Uganda, and this is true for other countries in Africa too, but I'm specifically going to focus on Uganda, widows and orphans are among the most vulnerable to property grabbing. Following the death of a male head of household, it's common for relatives, community members, authority figures, and others to plunder the property, including the home. Sometimes it's surrounding gardens or farms. We've had cases where perpetrators have burned down the homes to get the widows and children to leave the land. So there's a variety of different ways that this is done. Now, land security, as I said, is essential to security for most Ugandans, over 85% of whom live in rural areas and where agriculture is the major contributor to their livelihoods. When widows and orphans lose their property to property grabbing, they lose not only their homes and their personal possessions, but their sources of food and income. As a result, they become homeless, malnourished, driven into poverty, and potentially further exploitation. While the Ugandan Penal Code and other statutes do not include a specific offense called property grabbing, the act of stealing a widow's land violates numerous criminal statutes. Although many of the property grabbing perpetrators attempt to hide behind customary practices of refusing women and children their right to own their property, the Constitution and the laws of Uganda supersede these traditions, guaranteeing the equality of land and inheritance rights between men and women, as well as equal protection of civil and criminal law. Unfortunately, property grabbing against women in particular remains entrenched in the societal and gender norms of Uganda, and the Ugandan public justice system has not historically delivered on the protection and the security promised by the laws. IJM recently completed a study in Mukono County, where Grace is from, to document the prevalence and impact of property grabbing among widows in Uganda and the effectiveness of the justice system to respond to this. The results were bleak. We found that nearly 40% of widows faced an attempt of or actually experienced property grabbing in her lifetime. Now, 40%, this struck me. Actually, this type of injustice really struck me when I started working for IJM. Going in to work with IJM, I was actually a donor before I was working with IJM, I was fairly familiar with sex trafficking and forced labor, which I would say are the more well-known case types that we deal with. Those cases tend to be a bit more complicated, though, and you're often against a criminal enterprise, a powerful brothel owner, a successful brick kiln owner that's using forced labor. Sometimes alleged debts are used or supposed contracts, all of which is illegal, but it's complicated. Property grabbing, on the other hand, seems fairly straightforward. The law says that the widow is entitled to her land upon the death of her husband, whether her name is on title or not, and there is no criminal enterprise being threatened. So then, why did it take us 2 years to complete Grace's case? And why did we have to get involved in the first place? In addition to studying the prevalence of property grabbing, the study that I mentioned also looked at the response of the Ugandan public justice system and several related factors. And found a few things. I'm not going to talk about them all, but just a couple of them. One was that there are several, what I'm going to call protective factors against property grabbing that were found. Marriage formalization, existence of a will for the husband, land documentation. Though none of these are actually legally required in order to assert title, the absence of these often provide roadblocks. Barriers to the engagement of police and barriers to the progress of criminal prosecution were also found. Some of these barriers were simply lack of knowledge of both the widows and the justice system officials. Fear of reprisal for, again, both the widows and the justice system officials. Another barrier is just the disproportional burden placed on the widows in terms of having to offer evidence in order to obtain justice. Lack of resources and capacity within the system. So what can be done? What are IJM and others doing in the face of these entrenched societal norms and the high costs for many of the players in the system to move away from the status quo? We have found that there are some very specific ways of seeking justice and that we can affect change in these types of systems, both in Uganda and elsewhere. And I just want to emphasize two of these aspects. The first is that though our objective is firm and unwavering, in this case, protection and land rights for the widow and her children, how we achieve this is not predefined. We are not looking to impose our Western system of land registration, or for that matter, our Western system of how marriage unions are recognized. We are looking for what works in the given context and how to effect change that will be accepted and will be sustainable even after we're gone. There's a number of different actions that have been taken in Uganda specifically. One is fairly simplistic and actually doesn't change the root problem, but that's dealing with some of the protective factors. We work with community organizations to educate families on legal marriage documents, still not documents that look like our documents here, but what's seen as a marriage document there, wills and other protective measures. The second is more involved. The second thing that we try to do is more involved, and it gets at one of the key barriers, and that's the justice officials themselves. We tend to have what I call a carrot and stick approach when dealing with justice officials in different countries. I'm vastly overgeneralizing here, but we seek to develop relationships with key officials and policymakers. the individuals who are typically incentivized because of international reputation or other factors to see that the laws of their countries are enforced. So this is the stick when we're dealing with the local officials. We will call your boss if you don't cooperate. It's the carrot that we emphasize, though. The vast majority of the public justice system officials that we work with, whether it be police, social workers, or land title clerks, don't know how to effectively do their jobs. Looking at this in a different context, our founder, Gary Haugen, recently wrote a book called The Locust Effect. And in it, he states that if you watch CSI or Law and Order or any of those shows that most of us probably grew up on, we probably know more about criminal investigation than the average investigator in a developing country. So just lack of education, lack of resources. So what our carrot is that we will train these individuals and work with them to improve their system so that they can do their jobs. The jobs defined by their own laws and policies. And we've seen this work. In May of last year, one of our key projects in Mukono came to fruition. Since 2012, IJM and the Ugandan judiciary have been working to introduce significant reforms in two key courts, the Mukono Chief Magistrates Court and the Jinja High Court. In May of 2014, we were able to announce 4 key reforms. Organized filing systems. As an aside, this involved working with local volunteers and some U.S. volunteers to organize more than 100,000 court records in 2013. The other 3 key reforms include an electronic case management system, very simplistic. Again, probably not something you could even remotely equate to our land titles systems here. Stenographic recorders to complete records, and then other specific improvements for administration staff to reduce errors and opportunities for corruption. So our objective, protecting the widow and getting her land back, doesn't change. However, we're working within the system that exists and the laws that exist in order to meet the objective. The other key aspect to bringing about system reform that I want to mention is our staff. And Professor Trebilcock mentioned this in terms of his best practices as well. We have 3 key values at IJM in all of our field offices and in all of our supporting offices. We're a Christian organization, we're professional, and we partner with others. Our field staff are amazing. I've had the opportunity to now to visit 5 of our different offices and will be visiting Uganda in May. Over 95% of our staff are local. They're working within their own communities. Ugandan investigators, Ugandan lawyers, Ugandan social workers. They're also highly trained and very professional. They know what they're doing. This is key. Angie Redecopp, corporate lawyer from Calgary, Canada, as good of a lawyer as I might think that I am, and as well-intentioned as I may be, I'm not typically the best person to see a case through in Mukono County in Uganda. I don't speak Grace's language. I'm not directly familiar with her laws. Our staff do speak the language and they are familiar with the laws. They're from her community. So these are just a few examples of how IJM and our partners work in ultimately reforming systems or portions of systems in developing countries. It's not a quick process. It's not an easy process. We are seeing successes though. Reduction of property grabbing in Uganda, reduction of slavery in certain regions in India, reduction of sex trafficking in Cambodia, to name a few. I really could talk about the work of IJM forever, but what I'm going to do is I'm going to send around just a quick overview of what IJM does, and I believe Derek is going to open it up for questions.
My question's actually to Professor Redecopp, but I want to start with you just because to the comments is that I'm familiar with Cambodia, and in Cambodia, the Khmer Rouge came in, they had a history of a French system of property rights. The Khmer Rouge came in completely, one of the first things they did is went to the registry offices, tore up every deed that they possibly could have in order to get rid of property. In the early 90s, when Prince Sihanouk, the prince, got elected, Australia came in along with other governments and gave Cambodia the Rolls Royce of laws, and certainly gave Cambodia the Rolls Royce of property law. Unfortunately, it's the democratic culture of Cambodia that's the problem, not property rights. So while I'm certainly, I think we're all sympathetic to the issue of property rights being an important factor of creating a democratic society, it seems that, at least as I'm concerned, and Cambodia is a good example, that you really need a democratic culture more than you need the rule of law or property rights. So that's why I moved to Professor Redecopp, and what interests me about your organization is it is a faith-based organization. And so the question I have for you, and I sort of wish you would have talked about it more, is it's great to come out with, as I said, with these institutional or new institutionalist theory in terms of creating laws, but how do you see the connection in terms of developing democratic culture to, and you are, I don't want to say a Christian evangelical, I'm not so sure about that, but I know that it is a faith-based organization. You do create Christian missionaries where you go. Where do you see the connection between the Christian religion or Christianity or religion, for that matter, really, and the development of the rule of law and property rights?
Before I answer your question, just a bit of trivia. Right now in Cambodia, we solely focus on sex trafficking work, which we've actually seen a lot of success in and are looking at moving out of direct casework in that area and are looking now for an additional casework type in Cambodia. And we're actually looking at working in the area of property rights in Cambodia. So there's the trivia piece. In terms of the response, our faith base, Christian faith base, I would say goes to the motivation of our staff. At times, it directly impacts what we do. You know, in the area of aftercare, for example, you're taking girls out of brothels. They need many things. One of those things might be spiritual healing. However, we are not an evangelical organization. We are not missionaries per se. In many of the countries that we are in, Christian is a minority faith. Our clients are not Christian. Our aftercare providers are not Christian. You know, the lawyers that we work with are not Christian. So our mission is to rescue. It's not to directly evangelize. There are certainly interesting faith stories that have come out of our work, but our mission is not to directly evangelize. And I would say that's sort of the balance with professionalism and our Christian faith. So in some of the countries that we're in, they're far more interested in our professionalism than our Christian faith. In terms of what we're seeking to do, in terms of what IJM is seeking to do in the countries that we're in, we're working from the bottom up. We do have relationships with senior, government officials, but it's for the purpose of whatever that piece of casework is that we're doing. So I wouldn't say that we're a big player in democratic reform.
Doesn't democracy come before property rights? Can you have a strong private property rights regime without democracy? But this implies that there's some easy target on some other margin. That is, why don't we make Cambodia democratic and then we'll fix the problem? Well, it's not so easy to make Cambodia democratic. It's never had a democratic tradition. So it's not as though we're swapping one hard problem for one easy problem, right? We're swapping one hard problem for another hard problem. And I think the truth of the matter is even the assumption that democracy kind of precedes strong private property rights regimes is somewhat contestable. I mean, you think of countries like Singapore, which has a strong private property rights regime, but at least a soft authoritarian government for most of its history. South Korea, similarly, for much of its recent history. Or at least most of its post-war history, but a strong system of private property rights. So I think the connection between democracy and private property rights, maybe there's a positive correlation, but it's not perfect, right?
And I would also add to that, from our organization's perspective, we would not want to wait for democratic rights or whatever lofty goals that folks might have for a country to protect the widow or get the girl out of the brothel. So hence the bottom-up approach for us.
Drawing on your vast experience and hearing your comments this morning, if I was interested in furthering the lifting up of peoples around the world, would I be best to focus on governmental action or private action, as you've observed through the decades?
I don't think there's a yes or no answer that applies across the whole of the developing world. That's 150 countries accounting for, 4 billion people or something. I think the tendency to over-generalize is one of the absolute worst vices of the whole development field, right? So I think in some contexts where you've got an autocratic, repressive, kleptocratic government, it's hopeless to look to the government as, in the worst case scenario, as the source of useful reform. So there it seems to me obvious that the civil society route is superior. So that may be the Democratic Republic of the Congo kind of example. In other cases, the government's record is more mixed, right? It's corrupt in some respects, incompetent in others. There are other clusters of government activity where the government is reasonably competent and reasonably effective. So there it may be, there's room for partnerships of the kind that Angie was describing between civil society groups and particular clusters of civil servants. But I think all of this is going to be very context specific. I think that's the message that I took away from Angie's comments. That, dealing with sex trafficking in Cambodia doesn't have a whole lot in common with dealing with the property rights of widows in Uganda. So, what is an effective strategy in one context, it may be totally ineffective in another. I think this is it drives my students crazy to keep telling them this, right? That there isn't a silver bullet. There isn't a silver bullet, right? There have been lots of charlatans that have peddled silver bullets over the decades in the development field. Charlatans, I shouldn't say that. Charlatans are well-intentioned but grossly misplaced folk. And nothing is to be gained by perpetuating the notion that there's just one thing we could do, we would make the whole world rich. I mean, it's preposterous, and we should stop making those kinds of claims. In many ways, it's chastening. It would be much better if I could come here today and say, I have it, right? Everybody else who's thought about development since the end of World War II got it wrong. This is the answer, right? But if I knew that, I wouldn't be here. I'd be out making the poor world rich and taking a tiny percentage commission on their increase in growth rates, right? And making myself rich into the bargains. So I think it's no embarrassment to say that I don't have a silver bullet. The only thing I would say in my own defense is nobody else does either.
And just to add a bit of an illustration from IGM's perspective, we don't have the silver bullet either, and I think our approach has really broadened over time. So when we started, very much our niche was, justice system, working with police, training police, doing undercover work, closing down the brothel, and that's still core to what we do. But over time, I would say we've branched into both of the things that you're asking about. One, we are focusing more on relationships with government, more on finding those key policymakers that do have influence, are not corrupt, and will work with us. On the other hand, we also have been focusing more on aftercare support for survivors and developing communities around those survivors that will support them such that they won't be re-victimized. So I think over time we've become even, broader in terms of what is the response. It's all of the above.
When I hear conversations like this, it makes me realize what a rich heritage we have in our Commonwealth countries, in the common law, and our society. It's just a wonderful mix that has really worked out the best for us in a lot of ways, and that underpins the importance of what we're doing here today, because we're interested in protecting the institutions, the legal institution, the justice system, and keeping it, in our opinion, headed in the right direction so that we have a better, more prosperous society, but also one that's more just and produces better results for everybody. So thank you very much. And I think Marnie might have, I'm not sure on the schedule what it looks like right now, but I wouldn't be surprised if Marnie has some comments.
As you know from the schedule, that was the last panel of the day, so thanks for giving us a lot to think about to close it off. And as Derek said, to really put into context both why we're here and also sort of the degree of severity of the various problems we're dealing with, which is always important when you get wrapped up into thinking about the freedoms that are being denied in our own country. Sometimes we forget what the rest of the world looks like, and as both a cautionary tale, but also as reason for actual celebration and gratitude. So I did want to just close out. On the schedule, I think we've got 15 minutes for remarks. I don't have 15 minutes worth of remarks. I just wanted to say mostly a few thank yous. I began the conference by telling you about a lot of the people who have helped us put this conference together, and I just wanted to again remind you of those people, to thank them. Our sponsors, in particular, the Canadian Taxpayers Federation, McCaig Borlaug, Dr. Roy Eapen, James Jones, and several anonymous donors. So thanks to all of you for sure for helping us put this on. And also there were a whole lot of people who got on calls and helped to organize this event. When we were having some of those early calls, I remember us talking about, well, maybe we should have questions in mind after the panels in case no one says anything. And it's been really wonderful to see throughout the past few days that certainly has not been necessary, because you've been a very engaged audience and have been certainly participating and provoking all of us to think further. Thanks to the speakers. And then finally, just to those people who were on the calls, which sometimes were very long. So Lisa Lahore, one of our board members, Kara Johnson, Matt Buffton, who also had a great seminar before our conference for students on Friday, Scott Reed, and all of the CCF folks, Karen and Derek for organizing the panels, and Russell and Adam for keeping us fed and with microphones and somewhere to be. So everyone worked very hard. And before we close, I also just wanted to call upon our chair, Andy Crooks, who has been extremely supportive, always of CCF, but also of this event.
Thank you, Marnie, and I too want to express thanks and recognize Lisa. Lisa, do you want to wave so people know who you are? And Lisa's with McCaig Borlaug, one of our key sponsors. We are Canada's and Freedom's defense team. And a year ago, we appointed a new general manager, Marnie, and it's such a welcome, such a happy event, rather, to see this conference reactivated. We had 80 registrants, a very solid response, and I hope and I pray that we'll be repeating this in the future. Certainly my vote at the board level will be repeating it, and Lisa will as well. It's been a great conference, an exciting conference. We're a bit like Johnny Appleseed, planting seeds for freedom and watching how they sprout in the future. So amongst all of the other thanks, I think we deserve, or rather one person in this room deserves a huge round of applause, and that is Marnie herself for conceiving and pulling this off. I got to tell you, getting whistles from a white right-wing crowd is really impressive.
Thanks very much, Andy. I mean, once again, thank you very much for joining us for this. We are Freedom's Defense Team is one of the taglines that we use, but of course we can't do that unless we actually have people who are believing that liberty is important and are believing that it's actually important to talk about it in Canada and to be actually holding our governments to account and be making sure that the rights we have are actually being protected. So thank you very much, and I will say let's see you again next year.